Hi, I'm Greg Dell with Dell Disability Lawyers here with Cesar Gavidia, and we're going to talk about one of Cesar's recently resolved cases against Metlife. And Cesar, this was a great victory, a sad case. You're going to get into the details, and I say a sad case because I think the denial by Metlife was pathetic, but I'm going to let you go into the details. So give us a little bit of background of the case and then the strategy that you took in order to win benefits for your client.
Sure. Greg, our client was an engineering manager for General Electric. He'd been there quite some time. He was approximately 58 years old when he was in this pretty bad car accident. Well, a car hit him, hit and run, while he was on a road bike. He woke up on the side of the road. The helmet he was wearing clearly probably either saved his life or prevented some really severe brain trauma and brain injury. But he did suffer some severe injuries to his spine. He had to undergo a spinal surgery, a lumbar fusion, to fuse like 3 or 4 levels in his spine. And ultimately, this guy was a really active individual before all this happened. I mean, he was always swimming, he was always cycling, he was outdoors, lived a really great, healthy lifestyle, and all that changed in like the blink of an eye for him. And he even then still tried to go back to work. Tried to go back to work for General Electric, tried for 2 months.
Shortly after the accident, after the surgery?
Actually, yeah, just about 3 months after his surgery, he tried to go back and found that he's just in way too much pain. He couldn't sit for very long at all, couldn't stand for very long at all. All of this was really affecting his ability to focus and work. And he was just in constant pain. So he had to go back out. He submitted another disability claim to Metlife, and they paid it. They approved it. They paid him for approximately 3 years when they decided to conduct a medical review.
Now let me just back you up 1 second. You said they paid him for 3 years. Did he have any changes in the definition of disability at any time?
So what's interesting about this Metlife group policy is that they do change the definition of total disability, and where you would see in most group policies a definition change come at 24 months, at 2 years. In this policy, it comes at 12 months. So he only had 12 months of own occupation coverage. In other words, he was in this position where he was earning upwards of $200,000 a year, high earning individual, and obviously, a very high level, high demand occupation. They found him disabled from that occupation, and then after 12 months, found he was disabled from any job. And this policy says any job which you're qualified by your education, training, and experience.
And it didn't have what's known as an income qualifier in it, where it says you have to be able to make 60% of what you used to make?
Right, there's no income qualifier. It's just straight, if you are unable to perform any job that you could qualify for based on your education, training, experience, you do not qualify for benefits after 12 months.
It was basically like a duplicate of a Social Security disability definition at that point. And it's crazy, though, that you say they approved him past that change of definition stage, and then within 3 years of his initial claim, now they say, we think you're better. So tell us what they relied upon.
Right, so you see that, okay, they approved him for 12 months. They must have done some sort of review at that point. Their physicians at that stage determined that he continues to qualify. And then 2 years later, they decide, let's do another review. It probably resulted from the reporting that he was making to Metlife. When they ask you in the claim forms, well, what are your activities? What are you doing? What is your treatment? He had exhausted all the therapies he could do. They basically sent him home with a set of kind of at-home physical therapies he should do. He should maintain light exercise. So he continued doing things like swimming in a pool. He really wasn't cycling or doing anything like that anymore. He was doing kind of at-home light exercises to kind of maintain flexibility, maintain mobility, because as you know, I mean, that's basically the advice of your doctors when you have these types of injuries. You do as much as you could possibly tolerate, because if you become static, if you don't, exercise to some level, your condition can likely deteriorate.
The doctor wants you to be more active as opposed to saying, go back to your job and sit at your desk for 8 hours a day.
Right. And so this physician reviewer that Metlife had contracted out to reviews the records, says, well, I find that the level of his exercise and his activity and these things that his doctors have basically prescribed that he go home and do is inconsistent with his complaints of pain and his restrictions or his limitations.
Right. Okay. So that's typical basis for denial.
Right.
They never physically examined him. They just used a doctor to paper review.
Right, and the doctor even went as far as to say, well, I've even reviewed the objective evidence, which included obviously a surgery, and find that there's no objective evidence to support his disability either. So naturally, when Metlife gets an opinion like that, the next thing they do is they terminate the claim.
Right. Okay. So what was your strategy once he retained you?
So I knew that what we needed to do was really drive home the extent of his limitations. I knew that their focus was about this objective evidence that they're saying purportedly wasn't in the file and these records that apparently I guess they'd decided that initially supported the claim and was sufficient to pay him for 3 years, but now suddenly it's not anymore. So one thing that was really important was to not just gather additional records and additional opinions from his doctors concerning the limitations and restrictions he has, but also to send him to a functional capacity exam, an examination that's going to really quantify and objectively determine the extent of his limitations. And basically what that testing had concluded was that he couldn't sit for longer than 15 minutes without having to do some sort of posture change, preferably lying down. Same with standing, walking, and there was basically he was capable of 3 hours of total work. And that's with those changes and with those
right.
kind of accommodations.
When you get a conclusion that someone could work 3 hours a day, it's below the threshold of even being able to work part-time. So that goes to say that a claimant doesn't have to be bedridden. If someone says, hey, I think you could work 2 or 3 hours a day, that could be okay.
Right. And mind you, this is a really driven individual.
Right.
He was driven his whole life. He was successful. He was physically active. And this was as much as he could do now.
Right. But 2 to 3 hours a day doesn't satisfy the definition of disability to be able to perform the duties of any gainful occupation, because a gainful occupation is not on a part-time basis. And that's important for people to understand, that when they talk about the inability, you must be unable to perform the duties of any gainful occupation, they're referring to a 40-hour work week, 5 days a week.
Right.
So
8 hours a day.
Once you got the FCE report, what else did you rely upon to submit a strong appeal?
So I thought that it would be a great idea to submit this FCE report to his doctor, because one of the things that had occurred that I noticed in the initial denial was that Metlife, now under these new ERISA guidelines, sent the physician review that they'd conducted the report to his doctor. And his doctor, for whatever reason, this is in the middle of the COVID pandemic. Many offices weren't even receiving patients face-to-face yet, and I'm sure that their offices were extremely busy with things, hadn't responded to that report. So I thought it was important for not only his doctor to address that report, but also to address the FCE, to look at the FCE and find that the findings of this FCE report that we'd submitted to them was consistent with his findings and his opinions, and it was.
And how extensive was the appeal the written appeal that you submitted?
Well, in terms of it being extensive, it's gathering this additional evidence, ensuring that this record is complete, and basically plugging up all these holes and these problems that Metlife is claiming we have. So we exhausted all means to do that, and that's how it basically led to a very prompt overturn of the decision.
And can you explain to people why it's so important to do all of that during the appeal, as opposed to what if this claimant tried to do this on his own and didn't gather all the information that you did, and then the claim was denied? Would you have then been able to go back and say, okay, I know what we need to do, and present new evidence to Metlife?
Unfortunately, most disability plans only give you one bite of the apple here with this appeal process. So if you miss it, you don't submit what needs to be submitted, you don't gather the evidence that needs to be gathered, you don't address the issues that need to be addressed, then your opportunity has been squandered. It's wasted, and you can't come later and fix it or finish it. If we proceed then to litigation, the administrative record is really incomplete, and it's not going to stand up to the very high level of scrutiny that's often applied in these cases at the litigation level, where a judge is sitting there determining whether the insurance company acted in an unreasonable fashion by denying the benefits. So it's very clear that if this appeal had gone through without an FCE, without his doctor responding, and it was to go to litigation, this would be a very easy win for Metlife. I'm pretty confident that the judge would find that they did not act unreasonably in relying in their doctor's opinion about the lack of objective evidence, or that there was, that there was inconsistency between the pain complaints and the activities.
What I want people to always understand about these ERISA-governed appeals, which is what we're talking about, which is 98% of these cases because they're employer-provided policies, is that this appeal is actually your trial. This is your opportunity to present all of your evidence, because if you don't present every single thing you have during your appeal, there is no opportunity to present new evidence. And so what that means is that if you were to lose this appeal and then you file the lawsuit, you can't tell the judge about anything new. You can't even tell the judge about, hey, after I submitted the appeal, I had an accident and re-aggravated my back and had another surgery. Judge can't know anything other than what happened up until the day that Metlife made their final decision to deny the benefits. And a lot of people don't realize that. And unfortunately, many people call after the appeal. They don't use a lawyer to help them with their appeal. They do it by themselves. And you look at it and go, look, I'm still going to help you and make every argument I can. But it would have been a lot better if we were able to do A, B, C, D, and E during the appeal. So luckily, this was one that you won the appeal. Metlife agreed with your argument. Not only is it great that you won the appeal, but a litigation takes 12 to 18 months if you had lost the appeal. And that's another 12 to 18 months that the claimant would have had to go without any benefits, and there's no guarantee that you're going to win in a lawsuit. So awesome victory. Likely should have never been denied. It was Metlife playing games as they usually do, relying on just a paper review without really knowing the facts. But luckily, justice prevailed and the right thing happened at the end, and your claimant got paid. If you're someone out there who has a Metlife disability policy, feel free to reach out to Cesar, myself, any of our disability lawyers. No matter where you live in the country, we'll immediately give you a free consultation, and we look forward to the opportunity to speak with you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.